Mumbai, representing the Chief of Army Staff. I would like to stand on the existing protocol to save time. What I'm going to read here is the input from the Chief of Army Staff as it represents the interests of the Nigerian Army. I'm directed to acknowledge your invitation with the Chief of Army Staff to the joint hearing of the National Human Rights Commission, Bill 2020, a request for input from the Nigerian Army on the bill as conveyed by your letter with reference National Assembly CJHL /02401/PH.4 2021 06 dated 30th March 2021. A careful perusal of the bill revealed that the Senate and the House of Representatives will deliberate on the National Human Rights Commission Bill 2020 in the joint committee session. The bill seeks to harmonize National Human Rights Commission Act 1995 and the National Human Rights Commission Amendment Act 2010, and to provide for, among other things, the repeal and the reenactment of the Establishment Act and amend the Act to strengthen the day-to-day powers of the Commission to conduct investigations and sustain contribution to the human rights funds for human rights activities in the country. The bill, which is divided into 4 parts, 24 sections with a schedule, also repealed the National Human Rights Commission Act, Chapter 46, N46, Laws of the Federation of Nigeria 2004, and the National Human Rights Amendment Act 2010, referred to as the principal act in the bill. Additionally, the bill is timely brought given the myriad allegations of human rights violations in the country of recent and the need to contain same in the interest of...
I think it will be better to have an abridged version.
Okay, okay.
An abridged version, please.
Okay, the abridged version now is at section 2, sub 2A of the bill. The word of High Court appears to be repetitive, as such the sentence of the Federal High Court of a state or legal practitioner, as such they should be deleted. Section 2, subsection 2B of the bill listed the composition of the Governing Council of the National Human Rights Commission, and the paragraph sub B 1 to 3 ex officio members were listed with the exclusion of the Armed Forces of Nigeria, the State Services, Nigerian Police Force, and other security agencies. It is humbly observed that any mention of stakeholders on human rights in Nigeria will be incomplete without the Armed Forces of Nigeria and the Nigerian Police Force, because oftentimes they receive the brunt of litigations in courts over alleged human rights violations. Accordingly, it is suggested that additional subparagraph could be added to the said section 2, subsection 2B to include the Armed Forces of Nigeria, the DSS, and the Nigerian Police Force. A representative each from the Federal Ministry of Justice, who shall not be below the rank of Director, Federal Ministry of Foreign Affairs, who shall not be below the rank of Director, Federal Ministry of Defense, who shall not be below the rank of Director, Federal Ministry of Internal Affairs, who shall not be below the rank of Director, the Nigerian Army, Nigerian Navy, and the Nigerian Air Force, who shall not be below the rank of a Lieutenant Colonel or its equivalent. 6, the Department of the State Security Services, who shall not be below the rank of a Director, the Nigerian Police Force, who shall not be below the rank of a Deputy Commissioner of Police, the Nigerian Correctional Services, who shall not be below the rank of Deputy Controller of Correctional Service. In the same vein, ex officio members are disenfranchised from voting during deliberations of the Council. It is humbly submitted that a human rights document such as this bill should be fair to all and accordingly accord every citizen right to be represented, since the ex officio members are also guaranteed their fundamental rights in the Constitution of the Federal Republic of Nigeria 1999 as amended, notwithstanding their offices or official duties. Accordingly, the proviso under Section 2, Subsection 2B3 should be either expunged or replaced with milder provision to read, provided that ex officio members shall have voting powers in the council. Section 5J of the bill listed one of the functions of the commission as receive and investigate complaints concerning violations of human rights and make appropriate determinations as may be deemed necessary in each circumstance. This raises jurisprudential question as to whether the commission is seized of judicial powers, since it could investigate and determine complaints. It is therefore tried that judicial powers are vested in courts and other tribunals in Nigeria only by virtue of the provision of Section 6 of the Constitution of the Federal Republic of Nigeria. It will also amount to travesty of justice if the investigating body determines the complaints and makes same enforceable, as it is a principle of justice, and no man shall be a judge in his own cause. The lawyers here no nemo judex in causa sua. It is also against the letters and spirit of Section 36(1) and 4 of the Constitution of the Federal Republic of Nigeria, which guarantees right to fair hearing before an impartial tribunal or body. It is worthy of note that in the armed forces of Nigeria, for example, by virtue of the provisions of Section 134, 2 of the Armed Forces Act, Chapter 820, an officer who is the commanding officer of an accused person or investigated the case shall not sit as a member of a court martial for the trial of the accused. The intention of the lawmakers here is to ensure fair hearing and approaching the case with a predetermined mindset or being biased. Section 5 sub R of the bill provides that where it considers it appropriate, with the leave of court hearing the proceedings and subject to any condition imposed by the court, intervene in any proceeding that involves human rights issues. The pertinent issue here is the bill did not state in what capacity the commission is going to intervene in the ongoing proceedings before the court. This is likely to be against the principle of law that where a matter is pending before a court of competent jurisdiction, it is sub judice. Thus, the commission could only come into the matter as an intervener or an interested party, and this shall be upon leave of the court. It is also important to state that the commission could rely on the provision of Section 3, sub E 1 to 5 of the preamble to the Fundamental Rights Enforcement Procedure Rules 2009, which among other things encourages public interest litigation and class actions. Hence, Section 5R may be redrafted to read where it considers it appropriate, with the leave of the court, hearing the proceedings and subject to any condition imposed by the court, apply to the court to be joined either as a party, representative of the parties, or an intervener in any proceeding that involves human rights issues. Similarly, Section 6(1) sub E of the bill empowers the commission to make determination as to damages or compensation payable in relation to any violation of human rights where it deems this necessary. In the circumstances of the case, this has been declared unconstitutional, and in recent decision of the Court of Appeal in the case of chairman and members of the Special Investigation Panel of the National Human Rights Commission on oil spills and environmental pollution and tree orders versus Total 2021, the court said, and I quote, "The appellant, not being a court of law, cannot therefore impose any fine, and any law or regulations empowering the appellants to do so are not only unconstitutional but capable of violating the fundamental rights of the representative as enshrined in Section 36 sub 1 and 2 of the Constitution." At Section 6 sub 1E of the bill, the word, okay, 2 was omitted, so this one could be replaced. Section 6 subsection 2 appears to have given the executive secretary the powers to issue orders, as it provides that, and I quote, sub 2, "Whenever it appears to the executive secretary upon information and after such inquiry as he shall think necessary, that there is reasonable cause to suspect that in any place there is evidence of the commission of any offense under this act, he may by written orders direct an officer of the commission to, and end of quote. Though under subparagraph A, there is a proviso that there must be a court order, it will be clearer if the sentence or clause commence with, I quote, subject to court order or upon an application to a court of competent jurisdiction. Alternatively, the word order could be deleted from the sentence to avoid misinterpretation. Thus, the sentence could be redrafted as, that is sub 2, whenever it appears to the executive secretary upon information and after such inquiry as he shall think necessary, that there is reasonable cause to suspect that in any place there is evidence of the commission of any offense under this act, he may direct an officer of the commission in writing to ... Subsection 6, section 3, section 6 of 3 of the bill is also derogatory of the powers of the president and commander-in-chief, and also the court of law, because it provides that in exercising its powers, the commission shall not be subject to the control of any other authority or person. The question here is, who is an authority or person as used